But what we're talking about is Harvey and you, how this thing has changed the world, if you will, and what the things we need to be doing now from a discrimination and a harassment standpoint, regardless of the size of your employer or the nature of your employer. This applies to all of us in all of our workplaces. So let's jump right into it. The whole Weinstein thing, it seems like it's been going on for a long time. That was July of last year, less than a year ago, before that happened, or when that happened, and then obviously everything else since then. And this cartoon kind of says it all. Harassment has generally been you as HR people putting out fires, or you as business owners putting out fires. You had a policy. You'd investigate claims when they came up, and that was the role. Uh, and what could be proven, what would we do? It was more or less, I guess, how to be a fireman or a police officer in many of these things, as opposed to the hardcore prevention. Well, if one thing we've learned, and I think everybody can learn from what's happened, is prevention is where your efforts need to be focused a little bit more, maybe than they have been in the past, in light of what is going on with these changes. So that's what I want to talk a little bit about today, kind of a program to at least you as entities can think about how can we strengthen, how can we make sure our employees are happy, comfortable, in a respectful workplace? How can we reduce the risk of getting a lawsuit for harassment? How can we reduce the risk for getting an equal pay type claims? And so that's what we're going to cover in our time this morning. This is, I had to quit finding pictures. It has become so many up there. I'm sure I left several off of the individuals that have been accused of this, some correctly, some incorrectly. I think this is him and these two got a bad rap, but whatever they were accused of proved really not to be true. But it changes lives for people on both sides of this when it happens. But since July of 2017, this has become a much bigger issue. And what we have seen, it is shocking, maybe not shocking because it takes a lot to shock me these days, but harassment, discrimination, and specifically sexual harassment isn't normally about sex, as they say. It's more about who's in power and exercise of that power. You can say guys like Weinstein and Matt Lauer were difficult individuals, but really it was the thrill they got out of exercising the power is what they say drove these people. Weinstein is still in intensive rehabilitation treatment in Scottsdale, Arizona right now. So he's still being treated for his issues. I don't know what Matt Lauer or any of the other ones are doing, but I can't talk to that. I can tell you what's happening in my world. And in my world, my clients are really putting more emphasis and focus on a stronger HR policy, procedures manual, and changing their culture. So that's what I want to talk about. I am a lawyer, obviously, but I was the president of SHRM KC, and I deal with you. I call you Sherpas. Is that all right? From all the stuff you guys carry around at all the conventions when you go to those things, you HR folks. So I deal with SHRM people quite often. So this is going to be more focused on what you guys do as business owners than really what I would say a lot as a lawyer. But what we're dealing with here is how do we change our culture and develop a culture that is based on, obviously, fairness, respect, transparency, such that employees in your workplace know that they don't have to deal with it. I say this as an HR issue only because I think you've got to be with everybody else leading this effort. But ultimately, when you look at all the individuals that are caught up in this kind of issue, it is generally not HR. It's got to be led from the top. You've got to get buy-in from the owners, the CEOs, whoever it might be, to do this. And I did a harassment training program for a pretty large client up in the Kansas City area recently. And we did two things. For the on-site people, the CEO attended every one of those 4 on-site programs. And he came in and he did 5 minutes right up front saying, here's what this is about. Here's why we're doing it. It's coming from me on down. We recorded that message then, and then that message led for all of the remote training they did all over 20 different states. That's the kind of thing we're talking about with leaders. It's got to be a leader taken in there involved. The one common theme when you look at all of these different kinds of events and incidents that have come up over the last, whatever it is, 9 months now, what everybody says was the least helpful was that there was not a a transparent, robust reporting procedure where people thought they could report it safely. That's the one common theme. Everybody here's done different things or was accused of doing different things, but people did not feel comfortable for whatever reason bringing it to somebody's attention to say, here's what's going on. Weinstein is known throughout the entire LA area as being what he was accused of, allegedly. I don't know that he's guilty of anything yet. Probably going to be criminally prosecuted for his stuff. Matt Lauer may be prosecuted if the allegation about drugging people is ever proven. It's all allegations right now. We don't know what happened. But the leaders is what it's got to come from so people feel safe reporting. So we're going to cover that as we go through a little bit of this discussion. I'm going to get on the other side so I can keep track of my slides better. It is all about respect. How do we make sure we have a culture of respect in our workplace? This is what I, in conjunction with an HR professional who runs a consulting firm up in Kansas City, we put this together as kind of a 10-step process that if you've got issues or you just want to strengthen what you've got, pointers from an HR standpoint and from a legal standpoint on what you can do to really help people change your culture and change your environment, or if it doesn't need to be changed, strengthen it in your own workplace. And I'm going to go over each of these in order, so I'm not going to cover them all one by one on here, but these are the 10 steps that we came up with. If you've got comments as we go along, this is one of those where what I love about the kind of work I do is it's legal work, it's business work, it's HR work, it's psychological work. I think it truly takes a village of people with different specialties, different backgrounds, different experiences to think this through. And I'm not saying I've got all the answers as a lawyer how to do this. I fight about this stuff in court. I fight about this. I train to help prevent it. But I'm really interested in whatever you guys might do individually in these areas that you think might make this program better, or this as we're going through it, better for everybody. So let's talk about it. Buying in from the top. If the top person involved in your organization can get behind, as you develop policies or as you do training, and really tell people, we really mean it. This is one of the most important programs we have. We want absolute non-discrimination, non-harassment. It comes from the top down. And most importantly, if you've got issues, we want to know about it. Report it to us. Report it through whatever your system is. By law, you have to have a system of reporting it, but encouraging it from the top to do it so that it's not just, oh, geez, it's the HR police again telling us to do something. It's the top owners and management of this company that believe in this program. As I told you before, I love if the CEO or owner or whatever top level you might have in your entity that you think would carry the weight necessary to make it not just HR's issue, to do it that way. I have done training at that company since 1997. We do annual training there. This is the first time that he attended. Now, he hasn't been the CEO all along, so it's not just the person there now, but the first time that he attended, and man, it was shocking the way people paid attention, and it was treated a lot differently when they saw that this was not just HR checking a box on a training program, but it's something that's important. So it really did have the effect we want to. So if you're not the owner, I've talked to a few business owners in here already today. You guys have the power to make things happen yourselves. If you're not the business owner in the room, I would encourage you when you leave here today, go back and talk to them. What can we do? Again, we're not just trying to be the soft HR people. From a business standpoint, this is the right thing to do. It's the best thing to do, and it avoids potential legal trouble now with what's going on. So talk to them about how they could participate in strengthening your program. The enabling, as I said earlier, how many people after the Matt Lauer thing hit came forward and said they knew about it? We knew it was going on, but didn't feel comfortable coming forward. It was surprising to me, and again, based on what I know, I don't know those individuals, I don't know those situations personally by any means, but that's what was reported, is that there was a culture in those organizations that you don't mess with either of those two because they are so powerful you will lose your job. And so that's how the culture was, because somehow at NBC or at Weinstein Productions, you didn't do that. And I still hear this a lot of times, that is how it was back in the 60s and 70s. You need to give the men or the women or whatever a break in this stuff. They're not ready for a new world on how this stuff works. And you know, logically, I wasn't an adult back in the 60s or 70s, so I don't know what that really is all about entirely. But legally, that carries no water. Nobody gets a pass on complying with the laws based on whatever things were like back in the 60s and 70s. So we've got to do that. When I was doing this program and working with my HR consultant, 70% of sexual harassment, not general, but sexual harassment that has occurred to people based on studies doesn't ever get reported. Historically, and for whatever reason, women have reported by walking, and that is quitting and leaving. So instead of bringing it up, and again, I'm not going to say I know the psychological or the workplace or any of that issues for why that statistic is what it is, but 70% of the people, women that have been exposed to sexual harassment in the workplace over their careers, addressed it by quitting and leaving as opposed to reporting and changing. And that's what the statistics show. How do we address that? One of the issues that I know HR people, and I've had this come up in so many, when I get pulled into sexual harassment investigations, and I'm pointing this out for a reason. A lot of people have said that they wouldn't go to HR because HR was friends with the person involved. And that shocked me how much I heard that, especially small businesses like yourself. If there's the perception that HR, you can't even go to HR because they're personal friends with the managers or supervisors, so the person felt there was no avenue. I typically see this in smaller businesses, by the way, rather than larger ones, where that's an issue. So how do you as an HR professional maintain friendships? I'm not saying you shouldn't be friends by any means, but how do you make sure that people realize being friendly with someone or being friends with someone does not mean that you would do your job differently? And to me, I think you have to incorporate that into your training and have a part of it that says, guys, here's the deal. I'm friends with everybody I can be friends with here, but I want to assure you that when I do my job, I don't care who I'm friends with, these policies are going to apply. And I oftentimes have the CEO now take, or the owner take that thing and say, here's what I've directed HR to do. Our HR people are going to be good people, and good people do the right things regardless of who they're friends with. And incorporate that into your training to remove that sometimes mistaken impression that HR only is there to defend the company. HR wears 2 or 3 hats, if you ask me, on this subject. First and foremost, you're there to protect the employees. Second, you're there to defend the company and do things correctly to make sure if something isn't happening, that you're doing the right things. And then only then is there to make sure you're legally doing what we need to do. If you're doing the other two appropriate up front, the third issue becomes less. But your role back in the day, I mean, when I started, this will date me a little bit, you weren't called HR. Who remembers the personnel days? Don't some of you young folks raise your hands, because I know you don't, because that was in the early 90s, I think, when people quit being called personnel, and now it's HR. But you're HR, human relations. How do we protect individuals, and what can we do in these areas to get this culture change so people can bring issues forward? Number 3, this is going to sound a little odd, and this I'll give credit to my HR person who I worked with to develop this kind of idea. It starts with hiring. How are you making sure when you go out into the world you're hiring appropriately? And one of the examples is the one we talked about already, the ban the salary talk. Do most of you? I do. I will personally tell you, I do this. I'm not just a lawyer. I manage our Kansas City office, all the attorneys, all the staff up there. When I'm interviewing somebody and we're getting around to, I ask, so what kind of compensation do you have now? I've never really looked at it from the standpoint of, is that somehow locking somebody in, even though I did lock people in based on that. If they were at 50 and we had to lure them away, I'd offer them 52 or whatever the number might be, not realizing that if a male attorney came to me and said, well, I'm currently at whatever, offering him more, and I might offer a female attorney less. It never occurred to me. So in compensation, things like that, how are we recruiting to get the most diverse candidates in these areas? How are we doing items to avoid pay stereotyping or job stereotyping, making sure there's fair compensation? Who actually participates in your recruiting? This stuff goes deeper into not just once they're already there, but how are we making sure we're recruiting effectively to get the right kind of people we want for our workplace. So those are some items that I would never have occurred to me, and it made me think a little bit about how not just I practice law, but how I manage people as well. That it does begin a lot in recruiting. This is something that I think is very critical and important. How do you bring people into your system? Both before the Me Too thing developed and became more prevalent, I've been working with a lot of clients that as part of their onboarding, they have a specific discussion about discrimination, harassment, and that policy. I'll bet most of you do that. Part of what we do as a firm, and we recommend our clients, is there's 4 or 5 policies you should discuss with employees specifically and get a signature on at the time of onboarding. EEO and discrimination is one of them. That's one that you should spend some time going over it. And the focus of that thing is, hey, we want you to read this policy, of course, and understand this policy. But most importantly, read the part about reporting and no retaliation. Our company takes it very seriously. If you've got issues with this, we want to know about it, and we can assure you there won't be retaliation, and we will address it. That's the part that I think, again, if you look at these Harvey Weinstein and those things, the reporting is the part that fell through the cracks tremendously in some of these high-profile ones. I've got a client that is, and again, this is the best practices that I think is brilliant. How many of you give employees a handbook and say, sign this acknowledgement that you received it, and you stick it in their file, and that's the last thing you really have done with the handbook after you've either provided a copy electronically or in writing? I'll raise my hand. We do that. This client is clever. And I worked with them to do it to make sure it was fine ultimately. It's not my idea, but I think it's a good one. After 30 days, they give all their new employees, they do as part of their onboarding, kind of a discussion and analysis. They do a test with a little prize. Not much, $20 gift card, something like that. And the test, they have to answer 10 questions about handbooks and policies. Where is the EEO section of our handbook? What page is it on? They have to write it down. To whom would I report issues? So am I allowed to work off the clock? So it kind of covers, not in your face, but kind of a hodgepodge of key stuff. No, you're not allowed to work off the clock. If I've got issues, I'm supposed to report this way. And at the end, they then have them do that test, and they give them their gift card. Welcome to the company after 30 days. Now, the good thing about that is it does the HR function of making sure people do kind of put some time into reviewing what's at our company. The Machiavellian, and the part I like about it, is I've used that test in cases now. So when we're deposing somebody and they say, well, and this again, this is the defense side, so I'm a different person when we're on defense rather than compliance. Handing somebody their own personal test in their handwriting in a deposition, saying that they understood if there was any issues with violations of discrimination, harassment, or whatever, they were supposed to direct it to here. And that person in their lawsuit didn't do that, and it forms part of our defense. Having it as a test in their own handwriting is a beautiful piece of evidence in a case for me. So it was never intended to be that way from the start, but it sure works that way for us in some of these cases. So that's something that they do, is what do you do and how do you make that part of your orientation process. When you look at some of the studies that are coming out of this, the Wharton School of Business did a study that showed that 77% of companies who have a formal mentor program say they significantly improved their retention of employees. So actually developing something to bring somebody in, assign them a person that is not just there to show them how to make whatever you make or do whatever you do, but integrate them into the company is great. I do a lot of union avoidance stuff, and for whatever reason, I probably about half my practice has become healthcare. Hospitals struggle a lot with employee issues and union issues. And we developed some as a union avoidance tool, an ambassador program, where every new employee, we trained up a whole bunch of our best leaders, our best employees, not management. It was important that it not be management, but our best employees at the company. And we assigned every new employee to one of these leaders. And they all have their group of 10. And for the first month, they're supposed to walk around, meet with them a little bit, buy them lunch a couple times, and really get that person integrated into the entity. And what we discovered, and again, this is an HR thing more than a legal side, is you all know who that 5% of your workforce is who is always complaining about something and they're always unhappy about something. And for whatever reason, they latch onto the newbies more than anything else. And so imagine a newbie coming into a company and their introduction is HR handing them a bunch of stuff to sign. Here's your supervisor, go to work. And then at lunch, the first person that jumps on them is your complaining worst employee. And what we're discovering is if you give them a really good internal mentor to meet with, to talk to bring them on board, you can counterbalance that kind of thing. And these kind of studies are bearing that out. If you do have formal programs or some sort of structure around not just getting them, here's your policies, let's get to work, but getting them integrated into your company, it will reduce your turnover and make it a better place where they're comfortable doing stuff at work. The Oracle case study is another good one, that 25% of employees who went through their mentoring also increased their pay compared to 5% of the employees who didn't. So not only do they stay longer, but they become better employees and they're more promotable because you're really integrating them into your system and they're staying and becoming better. 6 times more likely to get promoted is the other statistic. So on your to-do list, first item, talk to your ownership, talk to your executives. How do you change your culture or improve your culture, I'd say is probably the better way to put it. Second thing is mentoring going to be helpful? Would something like that help you with your team and help them get integrated into the program and integrated into your company better? Because it will have a change. It'll change your culture. This is one of the great quotes: an army of sheep led by a lion is better than an army of lions led by a sheep. How do we make sure our leaders are doing the right thing? And I don't just mean EEO training. I do not do this kind of training that we're talking about here. For my Kansas employers, Kansas Workforce Development has got this program now that they do free, where they send out people that do nothing but help train supervisors how to be better supervisors, how to be better leaders. I'm not familiar with a similar program in Missouri. I don't know if the folks at Connell are. They might have people in this area that do it. But how do we make people be good leaders? And I tell this all the time. EEO training, like lawyers or HR people to do, is often a thou shalt not training. Okay, we can teach you on what you cannot do under the law. We can teach you how to document better so that you can show that you're doing things correctly with regard to discrimination and those practices. What I am not qualified and I'm not the best person to do is how do we make you a better leader so that you know how to do these things. And this is something that I think University of Missouri does it now. I know Kansas State University has got an entire degree. It's a degree in leadership. It's a minor you can take now with whatever your other business discipline or whatever your discipline might be. How do you become an effective leader? I know we're not going to put all of our supervisors and stuff through college, but how do we make them better leaders so that they can really be better at handling the stuff that we do and develop these modern workplace leaders so that we can have the next generation ready to step in the shoes of those that are coming before them. So leadership training is another thing that I think is very important. Leave accommodation in flex time is another thing with workplace. And there's a few statistics here. I think it might be the next one. Let me go to the statistics first, and then I'll jump back to that second one. Of the part-time jobs in America, 82% of them are filled by women and 18% are by men. That's an incredible statistic to me. And I know I'm not saying this is a discrimination or anything. I don't want to sound preachy on that. Women, as the primary caregivers historically, fit better or were able to do part-time. So I get the demographic explanation. But that has significant impact then on compensation and all this other stuff. So how do we have that situation? A lot of it has to do with how do you enable female employees to better step away from the workplace for child care or those kind of reasons. Here's the legal side of this stuff. We've got the pregnancy discrimination law, and we talked about the Young decision this morning earlier about how we do now have to provide accommodations for our female employees to enable them to have children and go through that process. The FMLA also obviously applies. Kansas has a unique thing, which is very interesting. Missouri doesn't have this, but for those of you who might have stuff over the border, Kansas has a very interesting law on this. You cannot terminate somebody for being out on pregnancy. I actually put the quote of the law in there. And childbearing and rearing must be considered by the employer as a justification for a leave of absence. So you're going to run into these different laws in different states. So it's not just a a legal thing necessarily in Missouri, but in many states it is. That what do you have to do to better accommodate? If you go out to the West Coast now, I've been doing a lot of work, as I said earlier, out in the state of Washington. And in Washington, there is now paid FML, 100%. You got to pay them for 12 weeks. Paid sick days, where for you earn 1 hour for every 40 you work each year that you can take time off to care for your own illness or the illness of a family member. There's a mandatory requirement that you provide flex time to the extent possible in Seattle and Portland for people based on child care issues. So these kinds of things are again, spreading all over the place. Can you do any of that here voluntarily? Is there stuff that you could do that might strengthen your workplace in that regard to allow you to better recruit and retain these kind of employees? I don't know. Everybody's different, and this is one where I defer to HR experts, of which I'm not in this area by any means. But what can we do to provide for better leave time, accommodations, flex time to strengthen our workplaces in this area? And there's the statistic I showed earlier. I showed you this before, so I'm not going to spend much time about it. But the end result of all this things, both legal and systemic and cultural, is this hodgepodge of women employees making 80 cents on the dollar on average for men. There's a similar statistic, by the way, for minority employees, where if you're a minority and female, it's a double whammy where that drops down to like 60 cents on the dollar. Minority males, believe it or not, in general are making more than non-minority females on average by comparison. So a minority male in the same occupation as a Caucasian male, they're much closer together than women are. It's much more of a women or female issue. So here's the kind of stuff we're talking about that is happening. Paid leave on the way. We've seen where there's been some federal movement with that ridiculous incentive. There's been some talk. Rubio and Ivanka Trump developed this thing, it's dead in the water now, that was going to allow female employees to borrow from their Social Security money to pay for time off when they were younger. So effectively, it would allow them to say, okay, I'm going to start drawing down whatever I would have gotten in Social Security to have a child, which is great, but then when they retired, they would have that much less that they would get paid. So that's why it ended up dying, is you'd essentially be making women borrow against their retirement or their Social Security distributions. So that didn't happen. So this is much more of a state issue. We've got these 5 states up here that have already got paid FML, and just since I put this together, 2 other states, Washington and Oregon, have jumped on that. So it is very rapidly changing from a legal standpoint, not to mention what obviously people could do just in general to strengthen that. Now let's get into the legal side a little bit. That's kind of, I'll be honest with you, that most of that stuff is outside. I'm not good on the softer side of HR, how to treat people right. I'm a lawyer. We don't treat people right. Forget that. That's not what we're about. So that's you guys. You as HR professionals really can hopefully look at some of that and think about some of that. But when we get into developing a real EEO program, I've gone back and looked at our firm's model policy. And if any of you don't have policy on harassment and discrimination, we got a great free model. It's on our website. You can download it, do whatever you want. But it is long and it is definition heavy. What is discrimination? What is harassment? And I'm not saying you shouldn't do that, but I think even our policy, we should relook at changing this to see what's in there. Of course, you're going to have the definitions. I think you have to address social media as an employer, as we talked about. Have something in your policies dealing with, and your training. I do a scared straight training with supervisors and tell them flat out, if you put stuff on your Facebook that we don't like and that shows that you're a bad person, that's going to be used as an exhibit against you in a lawsuit. So you may say, oh, First Amendment, I'm an American, I can put whatever I want on Facebook and social media as long as it's not related to work. And that's true. The government cannot prohibit you from doing that, but we as a private employer can do whatever we want to you based on it, and that means we can still fire you if you're a private. Those of you that raised your hand as public entities, rules are a little different for you there because you do have to follow the First Amendment. We don't as private employers. So what are you doing with your social media to deal with that? most of the time anymore when I'm doing training, I do not do employee training. I will not train your employees because that makes me a witness potentially if you get a lawsuit. So I don't do training for my clients' employees. Management's different. I mean, I can do management and supervisor training, but I don't do that. Your employee training, you guys have to work on that. Work with consultants or whoever you work with. But on the employee training, I spend a tremendous amount of time when I review and I help people develop them. It's got to be all about the complaint process, and it's got to be all about actual, real examples, not just definitions, but examples of what violates. And so the ones that I've seen that are pretty effective, you'll do all the definitions. Here's what harassment is. Here's discrimination. Here's how you report. And spend a lot of time on the reporting. Now let's talk about here's some examples. And go through kind of 4, 5, 6, whatever. What do you do in this situation? Is this harassment? Is this discrimination? How do you report it? That kind of stuff is what appears to have the most and best impact. One thing that we talk about, these are state laws requiring leave. Some of these states, California, Massachusetts, now legally require 2 hours of EEO training per year for managers, and I think it's 1 hour for non-managers. So this isn't just something that's, you're going to have to watch all the state laws. Nobody in our immediate area requires it other than Ellerth and Farragher, you know, the affirmative defense cases from way back in the day that say you should be doing that if you want to have an affirmative defense to say, we trained on it, they didn't complain like they were supposed to under our policies, so we get out of jail free, no case here. That's something you should do, but it's not legally mandated. In 2 states, at least, it is now legally mandated. So orientation annually, redistribute policies is something that I do encourage. We talked about the CEO doing stuff with kind of a top-down support and participating in the training. And what other policies do you have that relate? I've written or been asked to provide more amorous relations policies in the last year than I have in my prior 24. And that's all an offshoot of the Weinstein deal. I mean, are we going to, as an organization, ban people from dating each other? Most people don't want to do that. You don't want to have that situation. Are we going to ban supervisors from dating employees? Maybe not. But most, if you don't ban that, you have an amorous relationship policy that says, so whatever you're going to say, if you're going to date employees, you've got to tell us, and you're never allowed to date somebody in your immediate chain of command. If an amorous relationship develops, we're going to do something as an entity to make sure you're not supervising that person anymore. So those are becoming more and more common, and it's part of the whole, we don't want this direct influence chain of command going on with any kind of relationships. We're going to make sure there's protections there. Alcohol consumption. I tell you what, God's gift to the plaintiff's law firm has been Christmas parties. The stupid stuff that people do at Christmas parties where they're serving alcohol has resulted in more cases and claims that I've had to deal with in recent years. So Christmas parties or office, whatever they are, not just Christmas, are a challenge. But many companies are developing alcohol consumption policies. Because it's not just about the occasional policy, it's what happened if 2 salespeople go on the road or whatever, that kind of thing. So how's that related to well, it's clear how it's related. People, if they've had a few drinks, do things stupid and they shouldn't do maybe than they otherwise wouldn't. So what are you as a company going to do in that regard? And then social media are ones that I think you have to link up with all this and look at all your policies holistically to see what are we going to do? What do we as a company want to do? We're not going to be the HR, the sex police, but we are going to have a culture of respect, and this involves this. So some things to think about. I've talked about this before in my management side training, my supervisor, when I do that kind of training, we spend about 5 or 10 minutes talking about social media. Because as this says, believe it or not, people do stupid things online. How many of you, from an HR standpoint, have either come into work or otherwise and found something slid under your door or otherwise had an employee complain or notify you, you wouldn't believe what Joe did last night on Facebook? A lot. It's shocking to me how stupid people are. And maybe I just have too much of a rosy view of the world, but you'd think after 26 years of practicing law, I'd get up. But it surprises me every day when I walk in, and I will deal once a week with a call from a client. All right, this happened on Facebook last night. What do we do? Most of the time anymore, it relates to injured and ill employees. But many times it's harassment, discrimination. My most recent one was an employee on leave for a bad back who put pictures all over her Facebook page of not Disney, because Six Flags. It was in Texas or in Dallas. Riding all these roller coasters, doing all this stuff at an amusement park that had a bad back. And okay, well, what do we do with that as an HR? Well, there's steps you got to do, but if you can show that that is clearly outside what the doctor medically said they should be doing and went on the leave for, well, you can act on it. But many times, if you can't show that, then you're at risk. So there's a lot going on with social media you gotta be prepared for. So that's number 7. Get your policies in order. Get your stuff in order. Number 8 is conduct real training. We talked about it. Train like you really mean it. As I said, some states require. Others, it's part of the Ellerth and Farragher affirmative defense. Define and give clear examples. Go beyond and talk about what will happen in using real life and examples. And if you're interested, I can show you what I do, the examples I use. They're pretty simple, and anybody could get it, but it's by reinforcing it that way. You come to work and you over here as a supervisor, 2 employees talking in the break room, and one of them uses the N-word. A black guy uses the N-word to a white guy, and the white guy says, "Oh, I'm just an ignorant cracker." What do you as a supervisor do when you hear that talking in the workplace? 2 friends clearly just chatting back and forth. And real examples to make them think about how they do that is kind of what I'm talking about. So this is what I said earlier from the training. I do. Everybody remember the Scared Straight program way back in the day on TV? I think they've recreated it to. I think that actually is the new one, but that scared the hell out of me as a kid. It worked. And for those of you who are too young to know what it was about, they actually had kids that they would show going into prison that were at-risk kids, and the prisoners just tore them apart, screamed and yelled at them, and so they wouldn't do stupid things. Well, I think sometimes supervisors need to be scared straight a little bit. And in Missouri, that was very easy until last year, because in Missouri, supervisor could have been sued individually. Now the law's different. That isn't the case anymore. But they still can have bad things happen. You do bad stuff, we'll fire you. You do bad stuff, and you touch somebody in a way you shouldn't, well, you can still be sued for that. That's a tort, a physical touching kind of thing. So I think we need to, you can do kind of pretty decent hardcore training with the management team to make sure they're on board. Without it, I'm not saying really scared straight. You don't need that. But so many times, and again, I'll go back to that training we just did. Everybody knew it wasn't just the annual check the box training. When I started the program and the CEO walked in and did his kind of 3, 4, 5 minute, whatever it was, introduction to the training, it was a different world when that kind of thing happened. So this is what I talked about earlier. The true effect that is happening out of this, and I don't consider it a negative effect, is that we get a lot more people that are willing to bring this issue up. And that's a good thing to me. We can fix the challenges we know about, and so by having this, is we can have issues identified. So if you go back and look at your own policies and look at your own procedures, look at your own culture, what impediments might be thrown in the way of somebody complaining about issues like this? The law says you've got to have an effective and remedial program in place. Effective means you quickly investigate and review. Remedial means you take whatever remedy is appropriate. So how do you feel about the effectiveness, and put yourself in your employee's shoes? Would they feel comfortable with your reporting process? And if not, what do you do about it? How do you change that? What do you do to make it better? Because we're in a different world now with that. Real investigations. We're kind of on a clock here today, but I'm going to have some time to get to it. How do we really do these investigations, and how do we in HR make our investigations better? How many of you are actual SHRM national members in here today, or SHRM members? Okay. Go to SHRM's website and just type in conducting employee investigations. They've got about 10 different things you can download. And I'm going to talk about this in a second. Forms on how to do interviews, a flow of what you do first. And you can get good information to do that, to do investigations. And I'm going to cover that in a second. For those of you who are not, send me an email or something, because you got to be a SHRM member to access these things on the website, so you wouldn't be able to get them. But talk to one of your SHRM people that are members here, or if you can't get it from them, send me an email and I can just scan them to you. so that you can see them. Pretty good stuff to get way down in the weeds on how to do these investigations effectively. But really, the investigations define your culture more than anything. If there's one thing that will change a workplace for the positive or the negative, it's the employee perception on how issues have been handled. And if the perception is, man, he made a complaint of sexual harassment about his boss, and a week later he's gone, and then that's going to change your thing forever. On the other hand, if it's made a complaint, things were handled appropriately, then it's going to be a much better situation. So conducting investigations, obviously, first and foremost, is about that incident. But it's second about, you know, your workplaces. I know about your workplaces because I've been in thousands of them over the years. One event can change a culture because it becomes truth, whether it's truth or not, over time as it's repeated from generation of employee down to generation of employee. So how you do it is critical, and we'll spend more time on that at the end. These are the things that we're going to cover with our next PowerPoint, which the gentleman here will be queuing up for me in a second, I think. But this is what we're talking about. Develop a plan, all of this stuff. And again, since we're going to get to it, I'm not going to spend much time on this slide since it's part of our next program. The last thing, what are we going to do? Zero tolerance. Anytime you've got issues, and this is I don't want to say blame the people involved, but a lot of the analysis and a lot of the studies show that the reasons a lot of people don't complain is they don't want to get somebody fired. I was going to say something, but I didn't want to get him in trouble. He's 70 years old. He's been doing this kind of stuff, and it's just Joe doing that, so I don't want to get people in trouble. Or whatever else, if it's more hardcore stuff. But what I always have to point out to people, and HR, all of you know this, is zero tolerance doesn't mean if I use one naughty word in the workplace, I'm going to get fired. That's not what the law requires by any means. The law requires appropriate remedial action. That's the legal standard. So what are we going to do depending on what the person does? Termination is not mandated by any means in most of what I've dealt with. I mean, I deal with stuff every day where somebody's going to get fired because it's really bad. But that isn't always. That's the exception rather than the rule. The rule most of the time is, okay, there's going to be a warning or there's maybe a suspension or stuff like this. So we have to have all of these steps that we've talked about: good policy, good training, good investigation, and then prompt remedial action. Those are the four elements, by the way, of the Ellerth and Farragher defenses that I talked about before. But what do you want to do? I just negotiated a union contract in Olympia, Washington, and we put in there a last chance. In the union bargaining agreement, we put in there that if you have a last chance agreement, we can fire you whether it's 1 year from now or 20 years from now if you violate it again. And they asked us what could be included in that. We said, well, there's three basic things: a serious safety violation like a lockout, tagout, drugs. If you come to work testing for drugs, this company gives them one chance, and then that's it. And the other is if you engage in any kind of serious harassment or discrimination. And that's the one they objected to. Well, that's not fair. What if Joe just makes a stupid comment and that's hanging over his head for the rest of his career? We said if it was bad enough that it became a last chance, then yes, that's the rest of his career or her career, whatever it is. So you can do stuff like that to drive home the importance of it without terminating somebody. So that's kind of the 10 steps. The last part of this, and part of zero tolerance, is finishing strong. How do you do it? It's interesting to me, and I don't know where this came from, and maybe it's schools that are teaching this or somebody that's teaching this, is there's been this cloak of secrecy that some HR professionals think has to go over this. Oh, we got this complaint, we did an investigation, it's been taken care of, but I really can't talk to you about it. Just trust me, it's been taken care of. That may be the appropriate word to other people not involved, but when we're talking about the complainant, there's no reason you cannot tell them, and there's every reason you should tell them what the results of the investigation are. Hey, here's what we concluded. We did not find there to be discrimination or harassment because of this. We did find there to be some, and here's what it is, and here's what we did. We gave a final warning, we disciplined, we advised that if it ever happens again, the person would be terminated. We also advised them that they couldn't retaliate. And you all also should know if you're exposed to any kind of retaliation, whether it's the individual involved, their friends, supervisors, managers, whatever, report to us immediately. that is the science of it, as we say. You do have to notify them so that they know the remedial action was taken. Otherwise, they're living in this world of limbo and not knowing how it was resolved. So the law does say part of the prompt remedial action is notification to the complainant of what happened and what you did. You have to do that to take advantage of these defenses. The science and, again, the art is what level of detail. I mean, you don't necessarily have to get down into the granular and say he was suspended for 7 days and 3 hours and was notified, but you do need to give them kind of the whatever you think is appropriate to make it clear that the remedial action is taken. So that's the science and the art of that. Implement the decision. The no retaliation component is the key. All the studies show that another big reason people don't report is fear of retaliation. So we got to make sure that that doesn't happen, whether it's the witness or the complainant. I've got HR and others that, and I think this is a great practice. If you get a complaint of discrimination or harassment from somebody and you find that something happened or don't find that nothing happened, put it on your calendar. 30 days from now, I'm going to check back with that person to make sure there hasn't been any kind of retaliation or something. Check, and that's not just the complainant, but maybe key witnesses, so that you've got this follow-up. Again, from your standpoint as HR professionals, it's a good thing and the right thing to do. From me as a lawyer, I love putting somebody's calendars into evidence and any notes they take of that meeting into evidence, showing that not only did we do what we're supposed to, we're following up, and it's part of who we are to make sure it's taken care of. So it serves both an HR and a legal function to do that kind of stuff with those follow-up. This is the EEOC's position. You know, retaliation is the linchpin for all civil rights enforcement. If an employee is afraid of complaining, then there's never going to be enforcement of these laws in your workplace. So these are the kind of things you've got to worry about. I actually had a case, again, I keep picking on the state of Washington, but I do some work out there, where a guy complained of harassment. He wasn't gay, but they made fun of him and told gay jokes about him. Made a complaint, company investigated, made it stop. Comes to work a week later, and they had spray painted his toolbox. He was a mechanic. Pink, and put little rainbow stickers all over it. And wasn't happy about it, and ultimately he quit. Filed a claim against the company saying you didn't do enough to prevent retaliation. So that's the kind of things that can people, as Randall and I were talking about earlier, truth is stranger than fiction, and I'm preaching to the choir with that group. You know the crazy things your employees do to each other. I only get to hear the tip of the iceberg, so you probably got far more stories than I do on that kind of subject. So the bonus thing that I'll tell you in here, if you think you've got issues in your workplace and you're really going to do something to address it, think about whether you've got any kinds of serious skeletons in the closet, that you do not want to overemphasize this, or you want to emphasize things a certain way so that bad stuff doesn't happen to you right away. Those of you who are business owners is really, because if you've got a supervisor who you know has been doing things, and if you go out there and do a certain kind of thing right now, would you like a lawsuit with that kind of thing? So I'm not saying you shouldn't do these 10 steps at all, but what I'm saying is don't just do it without thinking as HR or an owner what fallout might be if you've got some challenges you need to address certain things before you really go robust in public with whatever changes you're going to make. Because I've got some folks that in certain industries that have to deal with that issue a lot. So ultimately, it's all about respect. Lady Justice is not kind. When you get into my world in the lawsuits, so whatever you can do to change your workplace or make it better and more robust is perfect. And this is one thing that is part legal, part HR. So it's got all that stuff in it. Already had that one. See, it's good when it's part. But the law has changed a lot is the purpose, and employers have to change with it. In how do they make sure they're really digging deep or looking deep to find the issues that are involved? That's what an effective investigation is about. And what you're all looking at this slide saying, what is that all about? Well, look really closely. This was in Florida that I did the program, so I had to find something in the Florida. Can you see that? Is that not showing out there very well? Yeah, she's standing knee deep in the water, and that's a giant alligator right there because she's not looking closely at what's going on. That's my kind of way of emphasizing we got to look at things. So we've got to be prepared to do better investigations than we have in the past to do this. We already talked about this, and this is the one I want to focus about on the time we've had here of this 10-step program. So how do we do effective investigations? Here's what it does. It demonstrates our commitment. It shows that to other people that might be involved that we're going to look seriously. It establishes these defenses. If we don't do an effective investigation, it doesn't help us because we didn't get out of it, and it can really hurt us. And I'll show you a case on how that has happened as part of this. And it can have a chilling effect on employees with complaints. So how do we know what we need to investigate? This is the question I get a lot. Well, they never really complained. If they do something like this, if they submit a clear written complaint, say, hey, this happened, well, you know as an HR person that you've got to start investigating. You've got a formal, verbal or written complaint, whatever it is. That's not a problem. But what if somebody just makes a comment? Well, you don't want to go over to Harvey's to talk about whether or not he's going to give you a job because everybody knows what happens over there. I mean, that's what Harvey Weinstein's issue was, the so-called casting couch. That if you wanted to work for him, you did this. Now, you're not going to have anything like that, I really hope. But what if you just get those kind of comments and complaints that are going on? Is that a complaint you have to investigate? What if you get an exit interview where somebody says, this is all the crap I had to deal with and that's why I'm quitting? Is that a complaint that you have to investigate? I would submit that that is. If somebody in an exit interview says to you, I'm quitting because the supervisor was so awful to me and this is what he did, I think you've got to investigate that. Remember that statistic. Most women, that's how they historically, statistically, have dealt with the issue, by quitting. So does that trigger in you a need to investigate? Probably so. By law, most complaints don't have to have magic words. When you start looking at these Ellerth cases and when the employer takes prompt remedial action, there are standards on what constitutes a complaint. There's no, I hereby formally would like to submit this complaint, signed, sealed, notarized. You don't have to have magic words. It can come through either formal or informal channels. I don't know if any of you utilize kind of a call-in or that kind of system as part of your process, in writing or not. I still have some companies that say, if you're going to submit a complaint to our company, you got to put it in writing. Don't do that. That's entirely not legally defensible to mandate it. Do you want them to say, okay, let's talk about it and get it in writing? Of course. But if somebody refuses to put it in writing, don't refuse to process it for that reason. That would get you in pretty bad trouble if things continue to develop. So that's the kind of complaints. This is the one I was telling you about before. This was posted on a guy's supervisor's Facebook page where they were dressing up for Halloween. This was slid under an HR person's door, apparently, by an employee. That's all it was, and you could tell, they could tell, I don't know who it was, the supervisors involved in this situation. This is not a client of mine, by the way. I didn't have to deal with this one, but this is what an employee slid under the door at Halloween. Would this trigger you as an HR person to say, okay, a complaint's made, I better be talking to these folks about it? I don't know. I would probably say, depending on more facts, that it probably was. This ended up being a pretty big deal at this workplace, so they did do all the stuff they needed to. But that's an example where sometimes complaints take an even unusual twist or an unusual form. So what is your role? Now we know we got a complaints filed. What are you supposed to do in HR? Two things. You're an investigator. You're trying to reduce the risk based on whatever's been presented to you. You've got to get to the facts. You've got to wear the two hats. What's fair to the employee, what we need to do to protect our company from the situation as well. And oftentimes those are the exact same thing. Fair to the employee does not necessarily mean against the company. It's you doing the right thing. And make decisions that are fair, legally defensible to a judge and jury. I've done an HR program before. Some of you might have seen it in various places that talks about the various roles that people play. Supervisors are like, in that thing, supervisors are the story writer. They're the author of a book. Every day that they come in, they're writing another paragraph, another chapter in that workday with their employees. You as HR don't generally see that whole story. You don't get that story every day because you only get what's brought to your attention. So you're editors of that book. So when they write their story and they deal with employees, you hope you've trained them well to write and do the things they're supposed to, so that when it comes to your desk, you can polish it, you can review it, you can go out and kind of change what needs to be changed. But you don't get to write that story much every day because that's the supervisors are interacting with your employees far more than you. So they're the author, you're the editor, your lawyers are the publishers. We generally don't get a chance to change the story once it gets to our desk. We just have to go out and tell the world why this story is a good story for our side of the situation. But we can only do so much publishing if the editors haven't done what they needed to do, and the supervisors and the authors hadn't done what they needed to do. So by the time it gets to me as your publisher, I love the story to just be something, we win, case dismissed, well done. I don't get that very often. But you as an HR folks have that opportunity to kind of refine and do things both at how you investigate, how you train your management team, and then how you would document whatever goes on. So this is the backdrop I look at it from anything that you guys do as part of an investigation, anything that you do that you put in writing. How is a group of 12 people who know nothing about my business, know nothing about me, know nothing about the situation other than what they're getting ready to be told in a 4-day jury trial, or if it's a governmental investigation, whatever they're going to do by interviewing witnesses or paper, how are they going to look at what we're doing? That's the standard you're looking at. Here's an example of how you do it wrong. I mentioned we'd talk about this earlier. This is an actual case. Castelluccio was the vice president at IBM. Got fired, filed an age discrimination case. HR went out and did their investigation. And they came back with an investigation report. This is a case where the HR was so much more worried about defending the company rather than finding the truth that when they wrote the report, when the company tried to put the report into evidence, the judge said this is so clearly false, so clearly biased, that I'm not even going to let you put your investigation report in front of the jury. They didn't include things like his performance reviews, which was good, evidence that was favorable, and ultimately the jury ruled $4.1 million in there. The point of this is, yes, you've got to keep constantly in mind what impact this document is going to have or this investigation is going to have in front of those folks, but you still, first and foremost, have to be fair on how you do it, because it's not going to have the desired result if you don't. So, investigation steps. We're going to go over these fairly quickly. Step one is you've got to move quickly. The law says you've got to take prompt, effective remedial action. That starts by the minute you get a complaint, you start doing it. What do? Delays create this perception to juries and others that you don't care about it and that you're not taking their complaint seriously. A lot of times when you're dealing with chronic complainers, I know there's this possibility, I don't know what I'd call it, where, oh, he's complaining all the time, I'll get to this when I want to. But just because they complain all the time doesn't mean they're not right this time. So you need to keep treating all complaints seriously, regardless of whether it's from one of your chronic problems or others. But we have to move quickly. So are these prompt or not? Tiffany made her complaint. HR was on her honeymoon. Didn't have her cell phone on. We don't have an attorney, and our outside attorney doesn't do employment law. So we waited till she got back from her honeymoon 2 weeks later to investigate the harassment complaint. Timely or not timely? The real answer is it depends. I don't know what the complaint was in this scenario, but generally waiting 2 weeks for something like harassment probably is going to be considered not quick enough. So the moral of that story is you need to have a redundant process in your system. If the HR is going to be away on her honeymoon, then we need her assistant ready so he can be prepared to do these investigations. Because a week or two, in many instances, if it's a nasty harassment, could be too late. You need to move quicker on that. I'm not saying you have to have it done in that period, but you got to get it started. Trey made his complaint right before the plant went into full shutdown. We shut down for retooling in July. So he made his complaint end of June. Nobody's around for a month. That could change things. I'm not saying you as an HR person could wait till everybody came back, but that means you might not be able to interview certain people and such. So there's rules or ways you can do this. We were too busy. That's almost never good. If you can imagine a plaintiff's lawyer getting in front of a jury saying, my client complained when people hung nooses from the rafters in their workplace, and HR didn't do anything about that complaint for 2 weeks. Sure, they cut them down, but nothing happened for 2 weeks. And my client had to walk through those doors. This is an actual case I had down in North Carolina. Walk through those very doors where that had been hung, where he walked in for 2 weeks, and this company did nothing for 2 weeks. So you can see how they spin that stuff and how they say that kind of stuff. So those are the things. So, got to be quick. That's rule number one. I don't know that this shows very well. This is sad. As I said, I just did this program down in Florida, and this slide initially said you've got to aim before you shoot. I did this program 2 weeks after their incident down there, so I had to change it and came up with this bird doing what he does this little girl. So I think that's a good slide. But you got to aim before you act. What is the one thing most HR people and others that I work with don't do? They don't have an investigation plan. What do you've got to know where you're going to go. I think there's a famous Yogi Berra quote that says you got to be careful if you don't know where you're going because you might not get there. You got to kind of have a plan, and that's what these SURE materials I was telling you about helps kind of down in the nuts and bolts granular area of doing these investigations. I think they're very, very good. So what are you going to have in your plan? You got to have all these elements. And again, we're running out of time here today. I don't want to keep you late. Each of these is covered. So each one of these is going to be in following slides that we'll talk about. Who will be involved? Will you start with your lawyers immediately? Will you utilize whoever you work with from your consultants to do that? It's going to depend a lot. Is this thing going to litigation? Is this going to be a bad one? We need to bring our lawyers in right away because we got to make sure this is prepped for litigation, not just prepped for resolution. Is it a complex question? Is it a very hard investigation to do, such that you think legal might need to be involved? Do we have the resources to do it internally? Again, I work with two consultants. One's based out of Kansas City. She's a lawyer. She does HR consulting now. I won't generally do investigations myself because if I do the investigation, I'm now a witness. I can't be your lawyer. I've just pretty much worked my way right out of the case. So I would have her come in to do investigations if the company doesn't have the resources themselves, does the full and complete investigation. So if you don't have the experiences or resources, is there an outside group you could turn to? It normally is not going to be your employment lawyer for the reason I just said. What's the cost of all this? Do we need stuff protected by privilege? I will tell people a lot of the times if it's going to be one of these highly sensitive stuff, here's how it works from here on. Everything about this you're copying me on with some sort of note that says we are sending this to our lawyer for legal advice. So if you're going to prepare a final report on something, I don't want to see final reports that aren't through any kind of communication with me until they're done and we've approved them, because that's discoverable in litigation. And not only is it discoverable, every edit you've made to it now, because in these lawsuits they don't ask for the written copies, they ask for electronic versions so that are metadata enabled. So they can go back and scan when and who made every change in a document and the changes that were made throughout. So they can see, oh, initially they said this and they changed the document at the end. And it's a gold mine for plaintiffs. So do you want to try and protect stuff because it's going to be a high-risk one? We're going to work through the lawyers on that. Other reasons counsel will be involved. Will there be something, that's what this picture is about. You think you're doing something cool and it ends up being something pretty boneheaded. This company, $2.2 million. They had an idiot who was going around, defecating around the plant and just leaving it there. Not the toilets, mind you. So this company says, we're going to get to the bottom of this. They were going to DNA swab all of their employees to do a test to see who the defecator was. Well, the problem is the Genetic Information Non-Discrimination Act says you cannot be gathering or getting information that you could then test somebody based on this kind of thing. So this is an actual case, and the jury ruled against them. So if you're going to do weird stuff as part of your investigation, talk to somebody about that first. In my world, weird stuff is oftentimes polygraph tests. There's a very specific law on that, and I've been practicing, as I said, since 1992. I have never ultimately had a client do one outside the banking industry, where they've got different stuff they can do there with security. But polygraph tests are weird. Recording interviews. I had clients that are, what do we do now? My incident occurred in Oklahoma. HR is in Missouri. We want to record the interview we're doing with this person as part of the process. Can we do that without telling the person we're recording it? Well, can you? Oklahoma's a dual consent state. Both parties have to agree. Iowa, if you do it up there, is a dual consent state. So that brings into the whole, okay, if we're going to record it, what state laws might get involved? So when you're doing investigations, if you're going to do unique stuff like this, check on that kind of stuff and talk to your lawyers about that. But 9 times out of 10, your conclusion is going to be, I will consult with my lawyers maybe, but I'm going to handle this on my own, and I'm going to resolve it, and then we'll deal with whatever. I would say 9 times out of 10, you don't even talk to your lawyers, actually, because it's kind of a run-of-the-mill. And then 99 out of 100, you then get a lawyer, or 1 out of 100, you get lawyers involved more, but that's that one. So who's going to lead it? The next question, are we going to have HRs lead it? Do we need an operational expert to participate in helping us review if it's a technical issue? Do we go outside and use consultants? Is HR been named? I mean, it's not uncommon for me to have situations where HR was named in the complaint, and then of course HR can't do it. Or a member of the HR department was named, and do we have to use somebody else? Does that somehow mean everybody in the department would somehow be conflicted somehow? What do we do there? So who will lead the investigation after you've talked to your lawyer? What if it's a high-level thing? The problem with the Harvey Weinstein situation is he ran the whole company. So anybody that you complain to, his requirement was if a complaints are made about him, HR had to tell him. And the only reason that stuff started coming to light is because people jumped outside and went to the members of the board. Well, unfortunately, who was on the board? Harvey, his brother. And so you had these issues. So if you've got the high-level stuff, how do you do it? How do you as an HR person make sure it's effectively done at the same time? You probably are thinking, well, I don't want to get crosswise as well. I've had people tell me that. Well, I can't do that. The CEO is best friends with the COO. The COO is the person who the complaint was made against. If I step in here, I could get in trouble. And then we use outside HR people sometimes for that. Kind of the whole thing. It's kind of weird how the whole president in the special investigations is who's conflicted out, who can do it, that kind of stuff. So that's the one to look at there. What will the scope be of the investigation? What are we actually having that's alleged here? And then, you know, we talked a lot about harassment, discrimination, but that's not what it's all about. You guys get complaints about everything, all of these other kind of things. And how do we investigate those? What are we looking into in terms of the scope of our investigation? What is our target date? You can't set this in stone. You don't know exactly when you're going to get it done. But when do we think we need to get it done so that we can talk to the complainant and say, hey, here's what we're doing. We think we're going to be able to get it done in this time period. We'll keep you in the loop as part of the process so that, again, you're doing the reassurances you need to protect the proper remedial requirements. Gathering the evidence, all that. So that's all part of your plan. That's before you even start it. SHRM, again, has a great checklist on here's the kind of items you need to think about. Then you need to start doing the other thing, preserving. This is a big deal. What information must be preserved immediately? We handle thousands of EEOC charges a year, complaints against our clients. By the time it gets to my desk, usually, a month or two after a termination has occurred has happened. So a lot has happened in things like social media since then. So if you're getting involved and somebody brings a complaint to you, you got to decide, what do I have to lock down and preserve? Our email systems, texts, for example. Texting is probably the biggest thing this day and age. What do I have to make sure doesn't disappear? The incident scene, if something happened, how do I photograph or videotape it? Surveillance videos. How many of you have surveillance on your property somewhere? Probably many or most of you. And I'll bet if you're like most employers, those are loop ones that after 24, 48 a week has gone by, those are gone. So when you get a complaint, what do you have to think quickly? Okay, this happened here. Video might be on there. I better make sure it doesn't get looped over. How do you get those kind of things so that you don't have things that disappear? Because as I said, by the time of Facebook, the very first thing we do when one of our clients has any kind of action brought against them by an employee, we do a complete electronic preservation. I've got a legal assistant, Carly, who knows how to do all this stuff. She will go out onto the web and she will, if she has access to somebody's Facebook, will store an entire electronic copy of it. If that person's on Instagram or whatever, we find everything out about the people that are filing charges against our clients immediately and lock it down so it can't disappear, because it can either help or hurt you, but we want to know it. So doing that kind of stuff might be part of your thing. I'm not saying you're going to do the full Facebook thing that we do, but what do you need to preserve that you control as part of it? Any kind of interim action necessary? Do I have to make people go to their own corners? Do I have to suspend somebody? What do I do to separate the individuals involved at this to make sure that I can do an effective investigation? What actual official litigation stuff has to be done? The very first thing you would ever see from me if I ever helped you with an EEOC charge or a lawsuit is a litigation hold letter. And that's my formal direction to you to preserve all of this stuff that might be part of the litigation. Do you need to do that when you get a complaint? Normally not, but it's going to depend on the nature of the complaint. You need to talk to your lawyers about that. What do you tell supervisors? And typically it's the IT people. If you've got a system where your emails drop off after 30, 60, 90, 365 days, whatever it is, how do we make sure we don't have our auto overwrite destroy stuff that might be part of evidence? And your IT people help you with that if it's part of the investigation. So that's really key. We've got to make sure we lock that down. Here's the various kind of stuff that you have to gather and review typically whenever you're involved with one of these kind of investigations or incidents that you have to review. Then we get down to the interview order. Again, there's no magic to this. There's kind of a rule, but it's a rule of thumb, not a rule of law. You obviously got to get the complainant side of the story and interview and get all that information from that. From that, you gather the background information. Okay, here's what the complaint was. Here's the stuff. I'm going to look at both their personnel files to see whether we've got any history here that we need to know about. And I'm going to get a pretty good idea of, now that I know what the complaint is, what the background is. Do you get the documents, videos? Make sure all that's looked at and reviewed. It's amazing to me how much is available in most workplaces now that can prove or disprove something. And I'm always, based on like we talked earlier, I'm always assuming now that things are recorded. I will anecdotally, and this is just me, I would say 10 to 20% of the cases I'm dealing with now and have dealt with over the last several years, a tape ultimately comes into play, or pictures come into play. Somebody was recording somebody else, and nobody knew about it. And the risk that we run into with all that is if we've got a supervisor who's, oh, that never happened, that absolutely never happened, I swear to you that never happened. Or the reverse, an employee says, this is what happened, I can prove it happened, this is what happened, and a tape comes out proving one or the other wrong, it changes the world. And unfortunately, as a defense lawyer, most of the time it hurts us more than the other side. Most of the time, an employee was secretly recording a supervisor, whether legitimately or for a nefarious purpose, tricked them into saying or doing something, or maybe they were doing something stupid. I mean, that happens a lot. The tapes are usually used against us, and we got to find that out early, because otherwise you get a guy staked out and lying, and you're done. It's just over. So witness interviews, non-witness, look at all that stuff, see what that kind of stuff might be out there. Do your witness interviews, subject, the fact witnesses, and you can flip-flop these. A lot of times people will do the subject and then the complainant and then the subject and then go talk to the facts witnesses. There's no obligation to do it that way. There's a lot of things that come into play. A lot of times you don't want to spread the issue to a whole bunch of other witnesses until you've talked to the complainant, because maybe they'll say, yeah, I did it, and you're done, and you don't have this whole thing that's going all around your company. So you don't necessarily have to have those in that order from a legal or a practical standpoint. And you go through that process. Witness interviews, what I really like about that stuff I've mentioned from Sherm and others is they've got pretty good ways to answer the questions. So you can do that. One of the legal issues that comes up in this, and this was under the old decisions, under the Obama board, believe it or not, that labor union law I was talking about works its way into EEO stuff, because under the old ruling from the Obama administration was you could not tell employees they have to keep investigations confidential, because part of being engaging in protected and concerted activity under the National Labor Relations Act involves talking about workplace issues and things. So if you were telling them they couldn't talk about it, that violates the National Labor Relations Act unless certain hoops have been jumped through. That's gone. That's not going to be an issue going forward. So that was the law under Obama board, is you could only tell them to keep it confidential if there was a risk of retaliation, a risk somebody would fabricate or destroy evidence, or a risk that people would collude. Now, if you tell people they need to keep it confidential during the investigation, you're pretty much going to be able to do that. Quite frankly, you probably would have been able to answer one of those questions yes anyway, even under the Obama Labor Board, that always could be present in an investigation. But that's one of the things when you're doing the interviews. Witness interviews, again, this is where you got to do the very first 5 or 6 questions are always this: who, what, when, where, how, why. I mean, you want to start, it's called the funnel technique. Tell me your story. Tell me what happened. And let them tell everything that you can, get all that information, and then if there's backup, start drilling down with more detailed questions. But these are where it's all about. You got to start with the who, what, when, where, or why. Do you use a form? I kind of like forms in this regard, and those, again, the one on Sherm are pretty good forms. They're good model forms. Do you make the witnesses give you their statements in writing, or do you write it down? I prefer, as evidence, that it be in the witness's handwriting. It's hard for them to say I didn't say it. If it's not in their handwriting and you take detailed notes or you write out a statement that they sign, okay, I I can live with that. I mean, there's a lot of factors that go into how you do it, but there's a lot of reasons you might not want them writing it down. Maybe they won't give you the detail you want, or that they might have told you verbally. So there's no legal requirement. It's just a practice thing. The more you can get detail in there about what their facts are, the better. No conclusions of the law. I hate it. Hate it, hate it, hate it. When you guys as the editors or the supervisors, as the author of a story, come back and tell me in a report, the supervisor or whatever, the other coworker, whoever it was, engaged in sexual harassment. Sexual harassment is not a lay term, so to speak. It's a legal term. It has to be offensive conduct. It has to be unwelcome. There's all kinds of these things that go into the conclusion of whether something is truly sexual harassment under this law. So an investigation that makes that conclusion is telling me a conclusion of law, not a conclusion of fact. Here is what the supervisor did. He inappropriately touched his coworker when she was working on a machine when he walked by and he brushed her backside. Afterwards, he made this comment. Pretty bad, right? Inappropriate touching. Sexual comment, boy, you got a lot of nice junk in that trunk. It's really looking good to me. Sexual harassment or not? That's the right answer. That's why I don't want to see a report. I don't know. Maybe it wasn't unwelcome. Maybe this was a boyfriend-girlfriend and she was perfectly happy with it. That means it's not against the law at that point. So I want those facts of what happened. And if one of the facts is, and they've been dating for 6 months and they always talk this kind of stuff and she says it to him too, okay, well now we just know we don't have a harassment case here. So I need the facts, and your lawyers need the facts, and you need the facts, not just a legal conclusion that may or may not be accurate. So, witness interviews, no magic, not a lot of magic there, and I'm running over my time. Professional, respectful, you got to do the assurances against retaliation. Use the funnel technique that I mentioned, and you're going to be in a much better shape. I say Joe Friday. Some of you might remember who that is. Some of you might not. But it's about those basic questions that get it started more than the gotcha questions. After you've got the basics, and you got to decide how to do this. If you've got proof, if you've got audio, if you've got video, do you let the person hoist themselves on their own petard, as the saying is, and you get them to lie to you, and then you say, well, by the way, I want to show you something. And I do that a lot of time in the union setting, because if I'm going to want to fire somebody, I a lot of times want to fire them not just based on what they did, but on the fact that that person lied to me as part of the investigation, because that stands up better sometimes in a union grievance process. So there's different ways to play the game that you'll have to talk about when you do there. Pitfalls there. What if the lawyer does things like asking to bring a lawyer? And there's a whole series of questions here that I would do. I want to get to the conclusion here, since I know I'm kind of going over my time. I tried to plug a lot of stuff in here. All of this stuff is going to be covered in your materials. A lot of times people boil it down to this. Oh, it's a he said, she said, so I'm going to do nothing. The EEOC says that's inappropriate. Juries say that's inappropriate. You've got to reach a conclusion. And here's how you're supposed to look at the things. This is what the EEOC says. Well, whose story is more believable? Yeah, it's a he said, she said, but who do you think is telling a more believable story here? Part of that could be based on what you've reviewed in their background or something. Maybe there's somebody that does it different or a way. What is the demeanor? Did somebody appear to be lying? He wouldn't look me in the eye, whatever. Who has a motive or reason to lie? What other evidence kind of supports one person's story over the other? Is it consistent with past conduct or the way this person has always done it? All those are supposed to enlighten or evidence a he said, she said situation. Now, ultimately, it might still be, geez, we do not know who to believe. And I've still seen clients that will take action. Okay, since we're not absolutely positive, here's what we're going to do. You two are absolutely separated going forward. You ever do anything, you ever do anything, and you do that, kind of go to your own mutual corners. You can do that if it's a minor thing. If it's a really serious thing like an offensive touching or something, you can't get away with that if that's what it involves. So you got to reach a conclusion and make your decision. Now, I know I'm out of time, and I know we need to get to Randall's stuff, so I'm going to end with these two slides here. One of the biggest things that I've seen when people do their investigations is they make a conclusion before all of the facts are in and before what you're clearly looking at should happen. That's frowned upon highly by juries. So don't make your conclusions, don't get it formulated in your head until you know what you're looking at. Now, some of you have seen me probably do this at Sherm. What are you looking at here? Once you see it, raise your hand, but don't shout it out. What's this a picture of? Anybody see it yet? Once you see it, you will never be able to unsee it. And that's the point here. If you form your conclusions too early, you won't be able to look at all the stuff that makes up the whole picture in a fair and effective way. Everybody see what it is yet?
Cow.
It's a cow. That's the eye. That's the eye. It's the head of a cow, more importantly. The nose. There's the ear. Ear. There's the head. Everybody see it yet? Some of you will never be able to see it. Your eyes don't work right, about 10% of you. But that's the picture of a head of a cow looking straight at you. Again, there's one eye. There's the other eye. There's a nostril. There's the form of the head. Ear, head, ear. You can look at it when you get the other stuff. All right, what's this a picture of? This is more of a perversion test than an eye test. That's just a white napkin folded on a black tablecloth, folks. Work with me here. So that's all the stuff that we really wanted to try and cover. And again, I apologize, we did run out of time to get through some of it, but it's in there. But that's what when you're doing your effective investigations. The last few slides are about making sure you're not doing retaliation and that kind of stuff, which we've talked about earlier. Here's what I will do. I'll stay around again for a good part of time as you go through the rest of your morning. If anybody has questions that you want to ask before I head back to Kansas City today, I'll hang out here and we can chat. But otherwise, Randall, thank you very much for having me. It's a pleasure talking with your group. Remember, there's always a shark in the water. If you need any assistance on this kind of stuff from a legal standpoint, give me a call. I don't charge people a fee or anything based on stuff that comes out of seminars like this. If you have a question you don't get to today, just let me know. Otherwise, thanks for having me.
Tim, thank you very, very much. Very informative. Good stuff. Good info. And again, thank you very, very much.